Hi, thanks and welcome to my second screencast for EDU 518. And the theme behind this one, eventually what we want to get to is some of the most recent law, like the Every Student Succeeds Act and, before that, No Child Left Behind. And also obviously filter in probably the two most important acts that we've had as far as education goes, special education, which is Education for All Handicapped Children Act, passed in 75, as well as that kind of morphed into IDEA. So a little bit of history as to how we got there. A lot of this, at first, there were lots of prior examples of special education being conducted prior to Brown versus Board of Education. However, most of those were done on an individual basis. They were not always done through by state laws, and not only that, but they were somewhat rare. Some of them dealt with as far as trying to help assimilate in children who were maybe non-English speakers as far as immigration and whatnot goes. But there certainly were examples of special education being done prior to Brown v. Board. I also think that it's important to note, as we're going to be talking about several of these court cases, that there are two ways to create law. And one is the way that we usually learn when we're young, and that's to have a bill go through, pass through the legislature, and then be signed into law by the president, or have the Congress override a veto. But the other way is through judicial review, and that's what happened with each of these court cases. So I am going to speak somewhat quickly, just because the recorder that I use does like to get this down to 15 minutes. So I'm going to try to squeeze this in. Brown versus Board of Education of Topeka, Kansas. It really was a landmark case in which the court decided that state laws establishing separate schools for blacks and whites was unconstitutional. And it completely turned the notion of separate but equal on its head. A case that had been ruled on in 1896 in Plessy versus Ferguson, which allowed for state-sponsored segregation. And as this map here shows you, there was certainly a reason for that. Down here in this area in the South, there was required segregation. In other areas, mostly in the North, it was completely forbidden. But then there was no laws in a lot of places. You can see all these yellow areas, state of Maine included. There was absolutely no legislation regarding that whatsoever. And so it dealt with segregation, and as we know with Brown v. Board, and we looked at in our case study, it also did a lot of other things because it really invokes a 14th Amendment. But I'll get to more of that in just a second. Here's just some photos of, again, maybe why they would look to do something like that. And of course, most of this is related to race as far as these pictures go, but there are some, like this picture down here in the bottom. Tell me that that's equal protection of the law when you have a classroom just crowded in, students don't have desks and those types of things. That tell me that that's equal protection of the law. So the Supreme Court heard the arguments over a 2-year period, and in 1954, Chief Justice Earl Warren, an iconic figure in our country's history, issued the Supreme Court's decision. All 9 justices agreed upon it, and they said that separate but equal for African Americans was a violation of the Constitution, and specifically, again, the 14th Amendment. And in that, Justice Warren says, education is perhaps the most important function of the state and local governments. It's doubtful that any child may reasonably be expected to succeed in life if he's denied an opportunity at an education. Such an opportunity is a right that must be made available to all on equal terms. Desegregation of children in schools solely on the basis of race deprive children and minority groups of an educational opportunity. We believe it does. And so, some of the impacts of that. The ruling laid the foundation for the 1975 federal law, which is now the IDEA, Individuals with Disabilities Education Act, which required access to a free and appropriate education for all children with disabilities. Before 1975, about 1 million American children with disabilities were receiving no education from the public school system. And since then, we've made progress in securing quality integrated educational opportunities for American children with disabilities. So, really multifaceted Brown v. Board, but it opened up the door because of what it said specifically regarding equal opportunity for Americans and invoking the 14th Amendment. And so after that, before we get into Hobson versus Hansen, in 1965 was when the Elementary and Secondary Education Act was created, and the purpose of that, as we look at this, chronologically, was to create, or was created to address inequality of educational opportunities for all underprivileged children. So then in '67, Hobson versus Hansen was a case that was heard in court. It began when a civil rights activist named Julius Hobson sued Carl Hansen, the superintendent of the Board of Education of Washington, D.C. And the question at hand was whether or not D.C.'s low-income students and African-American students were unconstitutionally being denied equal education. There's that equal opportunity again, due to the tracking system that was being used in district schools. And so what tracking is, you can see a chart over here, but district schools were grouping students by similar abilities, or what at least they said to be similar abilities, but we know that they weren't all of similar ability. And they were placed on one of 3 or 4 tracks, depending upon the school. And their track was determined by the outcome of an aptitude test, usually taken in elementary school. And in addition, African-American school teachers and administrative personnel were discriminated against in terms of their work assignments and promotions, because what they would do is place black administrators in the black schools, oftentimes with more difficult jobs because they were working with less funding and older schools and students who didn't always get busing and those types of things, and as well as their teachers. And it was believed that they were gerrymandering districts purposely. I know that's a government term, but they were gerrymandering school districts. And utilizing public revenues to improve the predominantly white schools while ignoring the need of the predominantly black schools. So Judge James Skelley Wright ruled that the tests that they were using did not measure the ability because that they were biased towards poor black children and standardized on white middle class. He also said that because the lower tracks provided less educational opportunity, that the tracking system was used that was discriminatory under due process clause, which we know appears in the Fifth Amendment to the Constitution. So what it did, it ordered the busing of African Americans to predominantly white schools. It pushed for teacher integration. It abolished the tracking system in D.C. It said no discrimination on a basis of racial or economic status in the public school system could take place. And it also helped lead the future practice of having IEPs, which obviously is so vitally important. The other thing is, you might ask, you say, well, maybe my school still has tracking. It's not the same type of tracking. Once students were in a track, they couldn't get out of it. And again, the tests that they're using to determine it were biased. Yes, we have students who are on a college track, while others are on maybe more of a career track. Those types of things, completely different than what we're talking about here in this Hobson versus Hansen case. Early 70s, several cases that happened all at the same time. Park versus the Commonwealth of Pennsylvania. In the state of Pennsylvania, a statute required that all children who attended public schools had to perform to a certain level or they were found ineligible to go to their schools. And children could be legally excluded from school if they had not attained the mental age equivalent of 5 years by the time that they were 8. My goodness, that's pretty scary. And that they were found not to profit, quote unquote, from the public school. Children with mental retardation were routinely denied school based on their ineligibility, as they called it. And, my word, we know so much about developmental delays and those types of things today. Hard to believe that this stuff was going on in the early 70s. And, hopefully, this goes to show how far we've come. Moving quickly, though. Parents of ineligible children had several options. They could send their kids to a private school. Many of them couldn't afford it. They could keep their children at home, but many of them had to work or were, not qualified to be teaching, and provide care without sending them to school, like maybe having a tutor, or they could institutionalize their child. And as I mentioned in my last video, Rosemary Kennedy, this type of stuff was done. The Pennsylvania chapter for the Association of Retarded Citizens brought a class action lawsuit in federal court on behalf of all children with mental retardation in the state of Pennsylvania from the ages of 6 to 21. And the defendants were the 13 school districts of that state, as well as the Board of Education and the Secretary of Education. And in the end, the court ruled that failure to provide access to public education violates, again, the 14th Amendment, equal protection. Failure to provide notification to parents regarding the evaluation process was something else, which is a denial of due process, which there again is the Fifth Amendment. So the same two amendments, seems like over and over. Again, government teacher and me, not surprised at all. And so the court ordered that the following measures were to be taken. School districts were required to identify and start teaching all children with mental retardation. School districts were to develop evaluations to determine the most appropriate placement. The State Department of Education was required to submit plans describing available programs, financial arrangements, and teacher recruitment, as well as training efforts to provide an education for students who they saw had mental retardation. And children under 6 years old were to be included for services beginning immediately. Park also helped set future precedent for many current special education practices, such as the concept of the least restrictive environment and eventually EAHCA. And then also in the early 70s, Mills versus Board of Education, like the Park case, was a class action lawsuit. It was brought by parents and guardians on behalf of all out-of-school students with disabilities. 7 children with a variety of disabilities, and you can read what they are on there, were certified as a class and came to represent 18,000 children who were being denied a public education in the city of Washington, D.C. The question at hand was the D.C. Board of Education in violation of the 14th Amendment regarding equal protection? If so, what requirements must be met by the district to ensure compliance? And was the district in violation of ESEA Title VI of federal program funds? Judge Joseph Cornelius Waddy ruled that publicly supported education is constitutionally guaranteed, and it's a right, not a privilege, under the 14th Amendment. He also said that due process of the law was not applied to children who were within jurisdiction of the public school system. So the court ordered that the district had to provide due process safeguards in regards to labeling, placement, and exclusion of students with disabilities from school. It's also ordered they also ordered the district to provide all children with disabilities a publicly supported education. So it's almost like you can see early on here where it's like, okay, we're not really going to provide an education to any students who we don't have to. If it's going to cost more money or if it's just a pain in the butt, then we're not going to do it. And then they found out, oh wait, we do have to do it. All right, then what we're going to do, it's almost out of sight, out of mind. So we're just going to, we're going to try to exclude as many children as possible. And then the ones that I guess technically we can't find loopholes for, then we're just going to put them in a different area of the school, not have them within the general population. And fortunately, the courts are saying, no, actually, you can't do that. You've got to put them in so we're going to see a least restrictive environment. One more case here from the early 70s was the Diana versus Board of Education case. And this case from the early 70s was another class action lawsuit on behalf of 9 Mexican-American students who were living in Monterey, California. They'd been classified as EMR as well. And the students had been placed in a special education classroom based on the results of an IQ test. The thing is these students were all bilingual, and Spanish was the primary language that was being spoken at home. And each of the students had performed poorly on exams in which they'd been given to try to determine their intelligence. But the plaintiffs claimed that the low test results were a reflection of language barriers, not learning disabilities, and that they therefore believed that the placement of the students in EMR classes constituted discrimination. So after the lawsuit was brought forth, the district reviewed the policies and decided that they had, in fact, been in violation of the 14th Amendment. The children were not offered equal protection if they could not comprehend the test materials, and that's what was ruled. The educators were to retest all the Mexican-American students placed in classes for students with mental retardation using designed assessments that were unbiased, and the tests had to be given early on, and in the primary language as well. What's funny about that is that what we found is many of these students, they weren't mentally retarded by any means. The test was biased towards them, and so it wasn't appropriately measuring their intelligence. And so nationwide, Diana helped lead the elimination of the IQ test as the sole measure for assessments for special education placement. EAHCA would eventually come along and mandate the use of non-discriminatory assessments, and there was an overall increased focus on special needs children who are culturally and linguistically diverse. So I'm at the 14-minute mark. I'm not going to reach my goal of being able to be done here by the 15-minute mark. So if you can hold on, I'm going to save this video, get that uploaded, and I'll finish with my final 3 slides.